Добър вечер, дами и господа. Включваме се на живо, защото днеска се случиха много неща в криптоиндустрията и изобщо в финансовия свят. В момента тече на живо изслушване на Комитета по финанси на щатите. Нека да го чуем и изгледаме заедно.
A lack of strong frameworks with properly regulatory oversight for the entities involved, particularly when they're commingling consumer and financial-based activities, presents additional levels of conflict and potential exposure to the underlying customers, either on the consumer side or
Thank you, Mr. Cabot. The gentlewoman's time has expired. Thank you, gentlewoman from New York. And now the gentleman from Florida, Mr. Posey, is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Allaire, you begin your testimony today talking about China's currency. Do you see any comparison between that and the central digital currency that the President has proposed in his executive order?
I'm sorry, I couldn't hear the last part of your question because the door opened.
So do you see any similarity between the Chinese program and the central currency that President Biden included in his executive order?
Thank you for the question, Congressman Posey. I think what the Chinese government has pushed forward with is an entirely state-run and administered digital currency program. It has with it significant embedded surveillance capabilities, and it's clearly something that the Chinese government seeks to export around the world as part of its desire to grow the role of the yuan internationally. I believe your reference to the executive order from President Biden was around studying central bank digital currency in the United States. Our view is that a similarly designed retail, government-run and administered central bank digital currency is not needed in the United States. But we do believe that there are critical improvements to be made in the core infrastructure of the dollar itself within the Federal Reserve System, what sometimes people refer to as wholesale infrastructure for this. And clearly central banks around the world are all exploring that. But I think this separation between those institutions that are delivering financial services directly to end customers and the government is a kind of air gap that is important to preserve for privacy, security, and market competitive reasons.
You can understand a concern of some people that if private digital is competing with government digital, guess who's going to win? It's never going to be a level playing field, and more levels of regulation isn't going to help. I mean, we know the SEC, the biggest fraud in history for 10 years they were informed about it. So, more regulation is not going to fix the fraud that we endure. And there's also concern, when you have a central bank digital currency, and like China has, the government knows every penny that you spend. They can slow down your flow of funding. They can cut it off, or they can take everything that you have. And I can understand the legitimate concern that some people have about that. How should investors evaluate liquidity risk of digital assets compared to banks?
So specifically on stablecoins, what this bill does is specify a very narrow base of important high-quality liquid assets that must be held on a fully reserved basis, the most liquid dollar instruments in the world. And a digital dollar that is held to those reserve standards is dramatically safer than bank deposits. Bank deposits hold 1/12 of the deposits. The remainder is lent out. We see risks from fractional reserving. And the mixing of that lending behavior and payment system behavior has, let's just say, bitten the American consumer and business many, many times historically. And so this bill, I think, helps to define and create the safest digital dollar in the world, which is what the American government should be getting behind and making that an important export product on the internet.
How should the regulations for stablecoins compare to the capital regulations for banks and money market funds?
So In the stablecoin bill, there are recommendations for federal regulators to look at capital adequacy, to evaluate key activities around the risks of an issuer, and I think that's appropriate. There should be capital buffers to deal with it. But unlike a bank, which is rehypothecating and lending and fractionally reserving, these are very, very narrowly held. And so the liquidity requirements are, and therefore the capital buffer requirements are likely going to be significantly lower. And so that is left to regulators to determine, as opposed to being highly prescriptive in the bill. But I think it's a very important and necessary piece for this to ultimately go into effect.
Thank you. Mr. Chairman, my time has expired. I yield.
Gentleman yields back. The gentleman from California, Mr. Sherman's recognized now for 5 minutes.
Thank you. This seems like the 12th hearing we've had on crypto this year. I'm still waiting for a hearing on diversity, equity, and inclusion in this room this year. But all these hearings seem to start with the idea that we're falling behind. America is behind Peru in cocaine cultivation. We are behind the Cayman Islands in nefarious hidden financial transactions. We don't always need to catch up. We're told that we now have a 160-page bill, and I'm sure a lot of work has gone into that bill, but it comes down to the one sentence and the one reason why Sam Bankman-Fried prowled the halls of this building, and that was to get the SEC out and put a patina of regulation in. Then there is the proposed stablecoin bill that goes to the lowest state denominator. And what state, if they could have $1 billion to provide health care for their own citizens who might die, what state wouldn't cut that deal and just provide whatever patina of regulation the industry wanted? And if North Dakota won't do it, South Dakota will. So we'll have achieved Sam Bankman-Fried's objectives. The least we could do is let him out of jail to come here and celebrate this is legislative success. When billionaires tell you that they're working to hurt your country, you should believe them. The head of Coinbase, Brian Armstrong, tells us that he views crypto as a new global reserve currency. And we see from others that this is the way, major figures in the crypto industry, that we can, a way to undermine American sanctions. The role of the US dollar allows us to have the know your currency rules. Crypto says it's hidden money. That's the name. Undermine our sanctions rules, provide a tool for tax evaders, but most importantly is what Mr. Brian Armstrong, CEO of Coinbase, says, and that is to displace the dollar partially or completely as a reserve currency. We're told that we need clarity. We have clarity. The SEC realizes it's a security, as Mr. Kaplan does as well. The industry is here to spend, well, first they're in court spending tens of millions of dollars to undermine that clarity. And then they're in Congress spending God knows how much to undermine the clarity that we could have tough regulation from the SEC, and that's what our laws currently call for. I've got a question for Avalanche Labs attempts to highlight their use of technology to focus on innovation, but still peddles unregistered securities to retail investors. The Avalanche token went from a market cap of $40 billion to $4 billion. Mr. Serrir, did Avalabs file a registration statement with the SEC? Has Avalabs sold unregistered Avalanche tokens or a future right to Avalanche tokens to raise capital?
Congressman, we complied with every regulation to the best of our abilities, and we are...
Did you file a registration statement or not?
When we did our token sale, we filed an appropriate...
Did you file a registration statement or not?
I do not know the correct answer to that. I'm a technologist. I don't know the answer to that. I believe that we did not.
Well, that would certainly surprise me. I mean, Taylor Swift turned down millions of dollars and responded to the community by saying crypto is an unregistered security, and she would turn down millions of dollars to be associated with it. Some people in this room are not willing to make that statement. Mr. Kaplan, you're able to comply with SEC regulation and carry on your business?
Yes, sir.
You filed a registration statement?
We filed through the licensing process.
So you got a license from the SEC. I would just say that we've had a lot of witnesses come before us, but we've had, I believe, not one who came here to talk about how if this works, it undermines the power of the American people.
The gentleman's time has expired.
Yield back.
I thank the gentleman from California. The gentleman from Missouri, Mr. Luchtermeyer, the chairman of the National Security Subcommittee, is recognized for 5 minutes.
Thank you, Mr. Chairman. I want to quote from an article in the Wall Street Journal last week entitled, "Crypto Communism Has a New Meaning. China Seeks to Infiltrate the U.S. Financial System, and SEC and FINRA Seem Oblivious." And in this article, it talks about Prometheum as an American company, but according to SEC filings, is a strategic partner and joint venture with Shanghai Wansheng Blockchain Incorporated and its affiliate Hashkey. The former company is a spin-off of Wansheng Group, which has deep ties to the Chinese Communist Party. Wansheng Group was founded in 1969, and the founder passed recently. An official press release commented that the comrade always listened to the party and followed the party. That group is now led by that gentleman's son, Lu Wangding, and the press release is almost identical by saying that he will carry forward the practice of the deceased founder and always listen to the party and follow the party. I can tell you from being on the Chinese Select Committee, that is a chilling statement when we have an American company that's in bed with the Chinese. Mr. Kaplan, what percentage of your company is owned by a Chinese entity?
I think approximately 20%.
20% of it. How much influence do they have over your company?
They have the same rights as other shareholders.
How much access do they have to intellectual property?
Wang Zheng has no access to any Prometheum code or technology or system, server, or customer data.
If they're on the board of directors and have access to all your data from the standpoint of being an investor, how do you answer that question like that?
The bylaws were changed in the filing that was filed with the SEC on November 2021, and they basically limit who has access to data, including directors.
Okay, where is the data stored right now?
In the United States?
Okay, your headquarters is here, your data is stored. It's not stored anywhere in China.
Not at all, sir.
Okay, you had a designation as a digital asset security broker dealer, and as such, you have a lot of person identifiable information on your clients, do you not?
Correct.
Okay, does any of that information or any of the technology does the Chinese have any access to that at all at this point?
Absolutely not, sir. I want to point out Prometheum is an American-born, bred, and controlled company, and basically no foreign influence or control over Prometheum is had to any of its systems, its code, its servers, or its customers' data.
Well, I'm glad you could read that, but that doesn't impress me because I sit on a committee, and I can tell you any company that is either owned by or are involved with the Chinese Communist Party and or government is influenced by them. That's the only way they operate. And so what safeguards have you got in place to make sure they don't get anything that's in your company?
Sir, we both had a CFIUS inquiry and an SEC investigation where we were required to give all communication.
So what benefit do the Chinese then involve themselves in your company? If they can't access it, if they can't access information, they can't access your technology, what's the benefit of them investing in your company?
The belief in the business idea that digital assets are securities and need to be properly regulated as such and traded on intermediaries that are properly registered under the securities laws.
Do you think that perhaps they're getting some information just by being around your business that could be helpful to them?
I do not believe so, sir.
Why did you take them on as a partner? Why can't you have an American partner instead of a Chinese partner? What's the benefit of having a Chinese partner in this business?
As anyone who's started a startup knows, when you are young and small as an entity and a large established entity seeks to have a relationship with you, you look for the opportunity. If there had been an American opportunity, we probably would have taken it.
Well, that's troubling because you see, this is exactly how the Chinese work their way into our various companies in this country. They see an opening because there's a need there for the company to grow, for money, for expertise, for technology, and they're standing there with their hands out, being willing to add that to the portfolio or give to whatever you want to do here. And as a result, then they've got their hands on you. It's very disturbing to see that that's what's going on here. So I'm just worried that this is a situation, and here we have the SEC getting you one of the first digital asset security broker-dealer's license. It's where's the SEC on this, I'm wondering. But anyway, I see my time is getting short. With that, Mr. Chairman, I'll yield back.
The gentleman yields back. The gentleman from New York, the ranking member of the Foreign Affairs Committee, Mr. Meeks, is recognized for 5 minutes.
Thank you, Mr. Chairman. I think most of you know I'm from New York, and I think you're all aware that the New York Department of Financial Services has created what I believe is a best-in-class licensing regime for virtual currency businesses, which I'm very, very proud of. And New York DFS is the only prudential regulator with virtual asset-specific authority in these United States of America. Under the leadership of Superintendent Adrian Harris, DFS ensures that consumers and markets are protected, and New York continues to be the financial center of the entire world. They've assembled the largest team of expert virtual currency regulators in the nation and have taken the strongest supervisory and enforcement actions of any regulator. So let me ask Mr. Arlea, who would you consider to be Circle's primary regulator?
Thank you for the question, Congressman Meeks. We are regulated similarly to virtually every other major electronic payment innovator in the United States. So we are regulated by many different state regulators throughout the U.S., similar to PayPal, Apple Pay, Venmo, Cash App, and others. So we're electronic stored value money transmission application, which requires us to be licensed, both a filing with the Treasury Department, BSA, AML requirements with U.S. Treasury, as well as licensing and supervision throughout the United States. We also have international supervisors that are central banks and market supervisors. We are also a BIT license company. In fact, we were the very first company in the world to receive the New York BIT license in 2015. We contributed to the development of that licensing regime. And we follow New York's reserve and disclosure requirements for stablecoins, which we would agree are some of the best available to the market today.
So are you saying, I just want to make sure that I'm clear, does Circle currently possess any type of virtual currency license in the domestic jurisdictions? Is that what you?
Yes, we have a BIT license, which is the New York virtual currency license, which they pioneered in 2015. Other states also have specific enhancements to their money transmission statutes that deal with virtual assets and interactions between the banking system and virtual assets. A number of large states do that already today. We're also supervised by international banking regulators such as the Monetary Authority of Singapore, the UK FCA, and others.
So let me, you acknowledge that states like New York have been leaders in this space, and you agree that they have a vital role to play, is that correct?
I absolutely agree.
So can you speak to why the existence of a state pathway is not a race to the bottom?
So I believe payment stablecoins, as identified by the Presidential Working Group and by the G20 as well, have the potential to be very large scale, much larger scale in use than many other payment technologies. And for that reason, it's been recommended that, by U.S. Treasury and by the White House and others, that there be national standards set for payment stablecoins. And I think that's exactly what, on a bipartisan basis, we're seeing happen here in Congress. And what's really key there is that there is a federally defined floor, that we do have the ability for federal regulators to define what that floor is so that there can't be a race to the bottom. And I believe the best states should be able to issue licenses and supervise firms according to this federal floor. And I think that's exactly what the legislation in front of us considers today.
Thank you. Let me jump to Mr. Garrison. Mr. Garrison, your assessment that the lack of clear rules of the road puts the United States at a competitive disadvantage deeply resonates with me. It's something that I've been talking about a lot. Like you, I hear regularly from U.S. companies that the lack of regulatory clarity at the federal level is causing them to consider moving out of the United States and seek to be regulated in other jurisdictions around the world. So I'd like to give you an opportunity to expand on this and share some of your observations in this area, and what are some of the potential near-term and longer-term impacts of industry participants leaving the United States.
So the regulatory uncertainty is tremendously difficult for people as they want to grow a business. And when they seek legal counsel and when they come to people like me, they are willing to spend money to comply with the law. They just simply need to know what the rules of the road are. And so it becomes incredibly frustrating when there is no clear rules of the road, and all you know is that an enforcement action may be hanging over your head, but there is no actual way to compliance. So one of the good things about—
Gentleman's time has expired. I thank the gentleman from New York. Gentlewoman from Missouri, Mrs. Wagner, the chairwoman of the Capital Market Subcommittee, is now recognized for 5 minutes.
I thank you, and I want to thank Chairman McHenry and our chairman of the Digital Asset Subcommittee, Mr. Hill, for their efforts to develop a much-needed framework that provides clarity to market participants, it promotes innovation, and protects investors. This hearing is timely, and the legislation that we're discussing today is critical to ensuring the United States remains the leader in technological and financial innovation. While Congress has been working toward developing a legislative framework, SEC Chair Gensler continues to regulate by enforcement. The SEC is actively policing digital asset markets through enforcement without clear authority from Congress and without providing a clear regulatory roadmap for digital asset firms. Meanwhile, the Commodity Futures Trading Commission, CFTC, has brought enforcement actions as well, including with regard to digital assets that the SEC claims jurisdiction over. Mr. Ollier, although the collapse of FTX did not involve payment stablecoins, one of the most egregious stories to come out of it was the commingling of customer and firm assets. Following your review of the draft legislation, does this draft fix the problems that we saw in FTX so we can provide increased protections to Main Street investors?
Thank you for the question, Congresswoman Wagner. I believe both in the payment stablecoin bill and in the draft market structure bill, I do believe that those commingling issues are absolutely addressed. And I think that's a critical issue that you've identified, and obviously a core to whether you're holding funds backing a stablecoin or you're holding digital assets that are on behalf of investors and users.
Absolutely. Last week, the SEC issued an enforcement action against Coinbase, alleging that they were operating as an unregistered broker-dealer, exchange, and clearinghouse. This action came after several requests from Coinbase, including a petition for rulemaking to amend the securities laws so that they could actually come in and register with the agency. Mr. Garrison, in your view, does this inaction on valid requests from the SEC, followed by harsh penalties against Coinbase, inhibit companies making good faith efforts to register, thus preventing job creation and economic growth within the stablecoin market, sir?
It certainly does. The lack of a regulatory framework makes operating a digital asset business in the U.S. very difficult. So allowing digital asset markets to operate with the acknowledgement of certain realities, such as instantaneous settlement of trading of digital assets that may be represented by securities alongside non-securities at the same time, these are important things to acknowledge. And I think this bill does a good job of identifying that and telling the SEC to start putting a regulatory framework in place.
Okay, Mr. Garrison, the proposed legislation requires the SEC to modernize a number of its rules to account for the realities of digital assets, including rules governing alternative trading systems and broker-dealers. Would you describe how these rules could be updated to accommodate digital assets and what impact these modernizations will have on the digital asset ecosystem?
So the secondary trading rules need to be updated to acknowledge that not all intermediaries are necessary, which is one thing that digital assets make possible. So those are rules that, by the way, even at the end of these enforcement actions, if the SEC is successful, these rules still have to be updated to allow for these realities of the technology to occur. So it's something that the SEC can do now, and the good thing about this bill is it requires them to act now as opposed to waiting till after the enforcement action.
And as my time is short, Mr. Garrison, development in the blockchain space is accelerating rapidly. Yet existing regulations make it difficult for everyday investors to participate in initial offerings. The new exemption in the bill allows participation of non-accredited investors up to a certain limit. How will this access benefit retail investors?
Improving investor choice is an important part of investor protection, as well as the key characteristics here of.
Are there protections too, sir?
Yes. So the disclosure requirements are included in the bill, the individual investment limits, the aggregate offering limits. There's limits on insider trading secondary trading from insiders as well.
My time's expired. I'd be interested in any other protections that you think should be added to the legislation. I thank the chair and I yield back.
Gentleman yields back. The gentleman from Massachusetts, the ranking member on the Digital Assets Subcommittee, Mr. Lynch, is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Kaplan, I'm going through the bill itself, and it's remarkable that the Commodities Exchange Act actually reads out of the law 4 major pieces of legislation that have been intrinsic to strengthening our markets. The Securities Act of 1933, gone. Securities Exchange Act of 1934, gone. Investment Company Act of 1940, gone, does not apply. Investment Advisors Act of 1940 does not apply. Sarbanes-Oxley sign-off of annual reports, gone. Matter of fact, annual reports are gone. All of these bills were put in place, right after the stock market crash in 1929. And because we had 9,000 banks in this country go out of business, fail, Congress, with the support of Wall Street, amazingly, at the time, came back and said, how do we restore the trust of investors in Wall Street, in the stock market, in our banks? And we came up with this menu of bills that tried to restore confidence, since our financial system is built essentially on trust. And we got trust by providing public information, to those investors right up front to build confidence in their investments. You've been able to follow those rules in establishing Prometheum. What do you think the consequences will be if new companies have the choice of either being regulated or as Gary Gensler has pointed out, operate like the Wild West? Where do you think, and especially if it's a state-by-state model where you can go to a state like New York, which has an established regime and somewhat of a regulatory framework, or you can go to some other state that is very loosely regulated. What do you think the consequences of those choices will be on the markets?
The American public will be harmed. Essentially, what we've seen is that the Wild West crypto financial services ecosystem focused on revenues at the expense of customers' best interests. The way forward, the best way, really the only way forward, is the application of the federal securities laws to ensure investors are protected. As you mentioned, sir, The major acts when it came to the securities laws were passed after the 1929 crash. We learned our lessons then. Regretfully, we didn't understand them now when we're in 2022, but now, in hindsight, it is totally clear that the best way forward and the best way to protect the public is literally the application of the federal securities laws. Now, I want to point out there's been discussion about a lack of regulatory clarity, and that's just not true. The SEC put the industry on notice in July 2017 in the Dow Report. The SEC has released compliant frameworks for the trading and custody of digital assets. Those who argue that there is a lack of regulatory clarity need a lack of regulatory clarity because they can't be compliant under the existing clarified regulations.
Mr. Kaplan, so the SEC has brought 130 enforcement actions and has won every single one of them. After each and every one of those enforcement actions, there's a written decision as to why that individual company was found in non-compliance. Is that instructive to the next company coming along? Is that instructive to you as a new startup?
There has been clear indication, whether it's on the release, the enforcement side, or the statements coming out of the SEC that the federal securities laws applied, and that those seeking to operate compliantly in the space when it comes to digital asset financial services need to comply with them. Basically, there's no confusion here. Essentially, the industry has chosen to ignore the clear statements, the enforcement actions, and the releases by the SEC because they were best served by not being regulated under the federal securities laws.
Thank you. You know, we have a few seconds left. What are the steps? What are the steps for registering and coming into compliance under existing laws? Is it onerous or is it balanced?
The steps are difficult, they're a little complex, and they take time, but they need to because when you're dealing with customer funds and assets.
The gentleman's time has expired. I thank the witness. Appreciate my ranking member and his good questions. Now yield to the gentleman from Kentucky. Mr. Barr is recognized for 5 minutes.
Thank you, Mr. Chairman. Let me start with Mr. Garrison and follow up with Mr. Kaplan's testimony. It seems that Mr. Kaplan is making the argument that everything except Bitcoin is a security. I want you to amplify your testimony in reference to this, what I think is Mr. Kaplan's testimony. In your written testimony, you talk about how the application of existing security laws that Mr. Kaplan says are perfectly applicable in this new innovative marketplace, that the application of these existing security laws to digital assets is not always clear, and amplify your analysis of how Howey doesn't really cover everything in the current modern world.
Yes, so we always start with the statute when the analysis of what is a security. The statute is quite clear in a list of instruments. Digital assets are not there. So then the question becomes, is it an investment contract? The Supreme Court in the Howey case put forth a test. It said a contract, a transaction, or a scheme where there's an investment of money in a common enterprise with a reasonable expectation of profit from the efforts of others is the security. Now, a digital asset at times can in fact be sold pursuant to an investment contract. That does not mean that the digital asset itself evidences the security for all of time. That set of promises that may have been launched if a project is getting off the ground and developing the network for the first time and raising money to do that, that's selling a token pursuant to an investment contract. But over time, tokens operate differently. They're not equity securities. They're not your traditional stocks or bonds or notes. People purchase them for a number of different reasons, but one of the reasons is they want to use it on the platform itself, on the network itself. So at some point in time, when the network is fully decentralized and fully functioning, that digital asset does not bear the characteristics of a security, and the application of the securities laws would be so overly burdensome that it would render the use of the network moot.
So in summary, what do you make of Mr. Kaplan's argument that existing securities laws are all we need?
I disagree with the position. I think securities laws are a piece of the puzzle, but I think there's a large piece of the puzzle that is missing.
Let me follow up with a question about custody. It's essential for any market structure legislation to set rules for the custody of digital assets so that consumers can have confidence that their digital assets actually are where an intermediary says they are. Digital assets raise several novel issues when it comes to custody that must be addressed. Mr. Garrison, would you discuss some of the key questions when it comes to the application of the SEC's requirements for custody of digital assets?
So, with respect to custody of digital assets in the SEC, there's a number of different questions relating to the intermediaries that may hold digital assets, typically broker-dealers, sometimes investment advisors. Generally, one of the questions that comes up and the core becomes, how do you demonstrate exclusive possession of a digital asset? The way digital assets work is you have private keys, and of course the private key may be shared with others and may be charted and put into different groups. So a lot of the securities regulations or debates going on in securities regulation is how do you actually show exclusive control? Now, the industry has a number of solutions that they think is sufficient, and the SEC has been talking about it and refusing to come up to a conclusion since, I want to say about 2018 on the subject.
Well, here again, the status quo is unacceptable. It's stifling innovation. The banks tell us that not just the SEC, but also the bank regulators are discouraging the safe custodying of digital assets, and that is stifling innovation here in the United States. We've got to fix that. Final question to Mr. Allaire related to China. Can you touch on how the United States can build out our stablecoin regime to elevate the United States leadership in the space without jeopardizing Americans' access to freedom, privacy, and apolitical private capital? And talk about that in contrast to what we see in China with the Chinese digital yuan, which has embedded surveillance features.
Thank you for the question, Congressman Barr.
And could you also touch on how a regulatory framework for stablecoin, dollar-denominated stablecoin, is an effective alternative to a CBDC or a digital dollar that would preserve the dollar's dominance globally?
My time is very short. In short, I believe private sector innovation with strong regulation at the national level for digital dollars, which is what this bill provides, is the best path to compete with China right now.
Thank you. And it's a longer answer, but I appreciate the answer.
Gentleman's time has expired. The gentleman from Texas, Mr. Green, is recognized for 5 minutes.
Виждате, дами и господа, за какво става дума. Такава битка се води в момента на американска земя за бъдещето на дигиталните активи. Долу в описанието има линк, който ще ви отведе до пълното видео на това изслушване в Съединените американски щати. Може да го изгледате. Най-вероятно ще го оставят и на запис. От мен това е. Сега трябва да приключвам. Лека вечер. От мен това е. Сега трябва да приключвам. Лека вечер.